Okay, this is file 25-22313-FH, People of the State of Michigan versus Justin Michael Snyder. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, going to have the attorneys place their appearances on the record. I'm sorry, Mr. Cree looks like he's a prosecuting attorney.
Yes, Phoebe McClure on behalf of the people, filling in for prosecutor of record, Mr. McCready.
Okay, thank you.
Bert Castleberry on behalf of the defendant.
All right, and Mr. Castleberry, where do we stand with Mr. Snyder's case today?
We wish to enter a plea. The agreement was sent into court.
I do have that. You want to state the terms of that for the record, and then I'll ask Ms. McClure to confirm.
Mr. Snyder will plead count 1, possession with intent to deliver methamphetamine, and there is a sentence agreement to probation with no upfront jail. All other charges will be dismissed, and including the second offense.
All right, Ms. McClure, is that a complete and accurate statement of the plea agreement?
It is.
Mr. Snyder, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Justin Michael Snyder?
That is correct, sir.
Mr. Snyder, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, possession with intent to deliver methamphetamine?
That is correct, sir.
Do you understand that the maximum possible penalty for that offense is up to 20 years in prison and or a $25,000 fine?
Yes, sir, I do.
Are you satisfied with Mr. Castleberry and the advice that he's giving?
Yes, sir, I am.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here this morning. Is that correct, Ms. McClure?
That is correct.
Mr. Castleberry?
It is, Your Honor.
Is that also your understanding, Mr. Snyder?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify if you wanted to testify. Do you understand, Mr. Snyder, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand that you're giving them up?
Yes, sir, I do.
How do you wish to plead to the charge that on or about May 22nd, 2025 in the city of Adrian, County of Illinois, State of Michigan, that you did commit the offense of possession of methamphetamine with intent to deliver?
Guilty, Your Honor.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No, sir, they have not.
Do you understand that if I accept your plea, you're giving up any and all claims that that plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter that plea?
Yes, sir, I do.
The prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Snyder to plead guilty?
None, Your Honor.
No, Your Honor.
Mr. Snyder, other than as we've discussed it on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, sir, he has not.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir, I do.
Is it your own choice to plead guilty?
Yes, sir, it is.
Mr. Castleberry, do you want to cover the factual basis?
I can, Your Honor. Mr. Snyder, on or about May 22nd, 2025, were you in the city of Adrian, county of Lenawee, state of Michigan?
I was.
And did you have methamphetamine with you?
Yes, sir, I did.
And you knew it was methamphetamine?
I did.
And did you have the intent to deliver at least a portion of that to another person?
I did.
I have no further questions.
Ms. McClure,
People are satisfied.
okay. Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Castleberry?
It has, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Snyder has had full knowledge of his rights and he's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we discussed on the record this morning. I will refer this matter to the probation department and set sentencing for November 6th at 8:15 a.m. Mr. Snyder, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Yes, sir.
And bond will be continued as it's currently set. Mr. Snyder, I'm going to put you in a breakout session with Ms. Teskey from the probation department. She's going to collect your contact information and give you some instruction on what to do next.
Thank you, sir.
And you can go ahead and log out right from there when you're done speaking this test.
Understood.
I think it's done that last night.
Okay. I have an unsigned one. He signed it. Thank you.
I'll give it to you. Julie did, so.
Oh, so we're all set. Thank you, Mr. Casper. Mr. Glazier, Ms. Ricker is here in the courtroom. Do you need to speak to her?
No, not at this time, yeah. This is just an arraignment, isn't it?
Yes.
Yeah, no, that's fine. We're just gonna ask for a pretrial a ways out.
Okay, give me 1 second. Ms. Ricker, you can come forward and sit at the table here closer to the television. This is file 25-22404-FH, People of the State of Michigan versus Penny Sue Ricker. We are here today for an arraignment in this case. We are proceeding today partially in person and partially by video conference. First, can you have the attorneys place their appearance on the record, beginning with Ms. McClure?
Phoebe McClure, on behalf of the people.
John Glazier on behalf of Ms. Ricker.
And Miss, you are Penny Sue Ricker, correct?
Yes.
Okay. Mr. Glazier, does Ms. Ricker wish to have the information read this morning?
No, we'd waive that, Your Honor. Note and put on the record that we have received a copy of that felony information and attached witness list. This time, Your Honor, she's going to enter a plea of not guilty, and we'd ask the matter to be set for pretrial about 4 to 6 weeks out.
Yeah.
Phoebe, is this your case?
It is Mr. Bayonetto's.
Alex is okay.
Okay, so I will then enter a not guilty plea for Ms. Ricker. We can set a pretrial for November 12th at 8:15 a.m., which should be 6 weeks.
Okay. Miss Ricker, if you want to come in and see me before that, set up an office appointment, okay?
Okay, I will.
All right, so November 12th at 8:15 a.m. Ms. Ricker, you can attend in person as you did today, or if you prefer to attend by Zoom, the bailiff will give you the video conference instructions. Great. Thank you.
Thank you, Your Honor.
Okay, we are back on the record then in file 23-21533-FH, People of the State of Michigan versus Julian Don Torres. Ms. Underwood, would you like to place your appearance on the record?
Ron Underwood for Mr. Torres, Your Honor.
Okay, and do you know how Mr. Torres would like to proceed today?
Your Honor, this is a violation of probation, correct?
It's a violation of probation and a contempt for failing to appear at the original summons hearing.
Okay, right. Then, okay, thank you. Yes, Mr. Torres at this time will enter a plea on these matters, Your Honor.
All right, Mr. Torres, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes,
And you are Julian Dominic Torres, is that correct?
correct.
Mr. Torres, do you understand that you have a right to contest this violation of probation charge and to have a trial on it?
Yes,
Do you understand that throughout that trial, you would be presumed innocent until your guilt was proven by a preponderance of evidence?
yes,
Do you also understand that you have a right to contest the contempt of court for failing to appear charge and have a trial on that?
yes,
Do you understand that throughout that trial, you would be presumed innocent until your guilt is proven beyond a reasonable doubt?
yes,
You would have the right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. And you have the right to have the court order any witnesses that you have for your defense to appear at your trial. Do you understand that?
yes,
You're not required to testify at your trial, and no one can say anything about you choosing not to testify or hold that against you in any way. Do you understand that?
yes,
On the other hand, you have the right to testify if you wanted to testify. Do you understand that as well? Sorry, the audio wasn't clear. Could you say that once more?
yes, Your Honor.
Okay. How do you want to plead to the charge that you violated your probation by failing to report on July 9, July 16, and July 23rd, 2024?
Guilty.
And how do you want to plead to the charge that you violated your probation by changing your address without telling your probation officer?
Guilty.
And how do you want to plead to the charge that you committed contempt of court by failing to appear at the hearing on those violations?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial, it's right to have your lawyer's assistance at that trial, as I have explained to you?
Yes,
Has anything been promised to you in order to get you to plead guilty?
no,
Has anyone threatened you in any way in order to get you to plead guilty?
no,
If I accept your plea, you'll be giving up any claims that pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the pleas. Do you understand that?
Yes.
Is it your own choice to plead guilty today?
Yes.
All right, so you had pled guilty in this case to attempted uttering, publishing, and you were placed on probation back in January of 2024. Is that correct?
Yes.
And one of the conditions of your probation is that you report as instructed to your probation officer. Is that correct?
Yes.
And despite being instructed, you did not report on July 9th, July 16th, and July 23rd of 2024. Is that correct?
Correct.
Did you change your address or move somewhere at about that time around July 24?
Yes.
And did you ever tell your probation officer that you had moved?
No.
As a result of that, we sent out a summons for a probation violation for a hearing scheduled on September 11, 2024, and you did not attend that hearing. Is that correct?
Yes.
All right, I will accept the pleas. Then they have been given understandably, voluntarily, and accurately. Mr. Torres has had full knowledge of his rights, and he has had competent counsel. The court has not made I'm sorry, I will refer this matter to the probation department for an update of Mr. Torres's pre-sentence report and set sentencing for October 17th at 8:15 a.m.
Your Honor, may I be heard as to the issue of bond, Your Honor?
Okay, go ahead.
Thank you, Your Honor. Your Honor, Mr. Torres is back in town. He has no intention of going anywhere. He will reside at he states to me he will reside at the address that the court currently has. And he would ask for a PR bond at this time, Your Honor.
Okay, Mr. Torres has stopped reporting over a year ago, and we haven't seen or heard from him until he was arrested on this warrant. So while I appreciate that he's back in town, it doesn't give me confidence that he would appear at future hearings. I think in light of that, the bond is reasonable where it's currently set, and so I would deny the request to modify bond.
Thank you, Your Honor.
Thank you. Mr. Torres, you can let the officer that's with you know that you're done with court for today. Okay, Mr. Murphy, are you going to need to speak to Mr. Wilson?
No, Your Honor, we can just proceed on the record.
Mr. Wilson, you can come forward to the podium. Jim. Okay, this is file 25-22373-FH, People of the State of Michigan versus Zachary Douglas Wilson. We are here today for a pretrial conference in this case. We are proceeding today partially in person and partially by video conference. First, we have the attorney's place there. Appearance on the record beginning with Ms. McClure.
Phoebe McClure, on behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Wilson.
And sir, you are Zachary Douglas Wilson?
Yes, sir.
Okay. Mr. Murphy, where do we stand with Mr. Wilson's case today?
Your Honor, I am here today on behalf of Mr. Malaro, standing in form. He's not able to appear today. Mr. Malaro didn't give me notes about Mr. Wilson accepting a plea today. As such, I was going to ask if the court be willing to set another pretrial on this matter. I don't know the length of time, so I guess whatever fits the court's schedule best. And then hopefully things will be worked out to get more progress on the case before then. But again, just an adjournment is what we're asking for at this time.
Okay, Ms. McClure, is there anything that the people need to address with the case?
Nothing to add, Your Honor.
Okay, let's set it then for October 29th at 8:15 a.m.
Yes, Your Honor.
And Mr. Murphy, can your office do the stipulation in order, please?
Yes, Your Honor, we can. Thank you.
All right. So, Mr. Wilson, your next date is October 29th at 8:15 a.m. Okay. Right, you can attend by coming in person like you did today, or if you want to do video conference, Dale has instructions to how to do that.
Okay.
Mr. Wilson, just try to reach out to Mr. Malaro sometime late next week, okay?
Yes, sir.
All right, thank you.
Yes.
Okay, Mr. Evans? No board and sit at the table closer to the television.
Judge, can I approach him?
Sure. Okay. This is file 25-22157-FH People versus Carlton Benjamin Evans. We are here today for a hearing on a summons for probation violation, and we are proceeding today in person. Sir, you are Carlton Benjamin Evans, correct?
Yes, Your Honor.
Mr. Evans, have you received a copy of the request and summons for probation violation?
Yes, Your Honor.
You had, in this case, been convicted of operating while intoxicated, third offense, and the maximum possible penalty for that is a $505,000 fine and either 1 to 5 years incarceration or probation in 30 days to 1 year in jail, at least 48 hours to be considered consecutively, and 60 to 80 days community service or rehabilitative programs. You are entitled to be represented by an attorney today and any other hearings that we have regarding this matter. If you can't afford an attorney, you can tell me that. I'll appoint one for you from the public defender's office. Do you understand?
Yes, Your Honor.
Would you like to be represented by an attorney today?
No, Your Honor.
Okay. My understanding from Mr. Stevenson is that he would like to push this out a ways and give you an opportunity to attend treatment and see how that goes. So what I'll do is enter a not guilty plea for you at this point. Set this out for a date in the future to give you and Mr. Stevens an opportunity to work on that. And I'm sorry, did you say December?
Yeah, if we could get like the second or third week in December.
Let's go with December 10th then at 8:15 a.m. So your next date will be December 10th at 8:15 a.m. And see you back then and see how things are. Okay, you're all set for today. Mr. Sinclair, are you ready to proceed with Mr. Vargas?
Yes, sir. I'm ready.
Okay, this is file 25-22318-FH. People versus Jake Jr. Vargas. We are here today for a pretrial conference in that case. We are proceeding today by video conference. First, I have the attorneys place their appearance on the record, beginning with Ms. McClure.
Your Honor, just for the record, there are two files, and Phoebe McClure on behalf of the people.
And good morning, Judge. I'm Christopher Sinclair, 80512, appearing with and on behalf of Mr. Vargas, who's present on the screen, that we consent to proceeding via Zoom.
Okay, and I apologize, Ms. McClure is correct. It's 25-22317-FH and 25-22318-FH.
Yes, sir.
Okay, Mr. Sinclair, let me first ask, I can see you're in a car. I just want to make sure you're not driving. You're pulled over and safely parked.
Yep, I'm pulled over in a parking lot, not moving.
Okay. All right, then. Where do we stand with Mr. Vargas's cases today then, Mr. Sinclair?
Yes, sir. So today is the date and time set for pretrial. From my perspective, we've exhausted all efforts to resolve these cases via pleas. So I'm just asking the court to set trial dates for each file, please.
All right, Ms. McClure, how much trial time do you think we'll need for these cases?
So this I am covering for Mr. Bandetto. He did leave me a note that he would like the trial set for 5 days. The only thing I'm unsure about is on which file, because obviously there's two files, and I'm just looking at the charges. I guess I'm not sure that they're related. So
They're
it
not
wouldn't be
really.
okay, so it wouldn't be a consolidated trial. So I don't know whichever one the court wants to set first. Usually the one with the higher penalty and or the lower case number. But Mr. Bandetto did indicate 5 days, and I do have his calendar for scheduling purposes.
The case with the higher penalty is the drug case. I don't have the case numbers right in front of me, so I'm not sure which one was charged first, but I know the one with the higher penalty is the drug case.
And that's also with the lower case number.
Yeah,
Okay.
okay. So,
Perfect.
so we'll set that one for 5 days then. Ms. Clark, can you give us a 5-day jury trial date, please, for Mr. Vargas?
Yes, March 31st at 9 a.m., April 1st at 10:30, April 2nd at 9 a.m., and April 3rd at 9 a.m., and then April 7th at 9 a.m.
I'm sorry, can I have those dates one more time, please? I was writing as fast as I could.
March 31st at 9 a.m., April 1st at 10:30, April 2nd at 9 a.m., April 3rd at 9 a.m., and April 7th at 9 a.m.
Got it. Thank you.
That does appear to work with Mr. Bandetto's schedule. I do just want to point out that Friday, that 3rd is Good Friday, and the courthouse is closed for a half day. So I don't know if that impedes the trial too much or not.
You could use April 8th at 10:30 and just cross
If-
out the 3rd.
If needed, okay.
Let's leave
Yeah,
the third
if you-
on, just add the 8th as an additional day so that we're sure we have enough time.
Okay, I was gonna say if we do take off the 3rd, that might work for jurors better as well, because a lot of people go out of town for Easter.
Yeah, let's just block off all the time and then we can make that call
Okay. Perfect.
around the trial. Okay, and then Mr. Sinclair, if you want to schedule a date for the next file, we'd have to go into June because we can't use the same jury panel.
Okay. Yes, sir.
So do you have any sense, Ms. McClure, of how long that trial might take?
Just because I wasn't sure which one he indicated would take 5 days, could we do 5 days for this one as well? And then I'll have Mr. Bayonetto contact the court and Mr. Sinclair if that can be changed.
Sounds reasonable.
That's fair.
Okay, so Ms. Clark will need 5 days in June or later.
Tuesday, June 23rd at 9 a.m. Wednesday, June 24th at 10:30. Thursday, June 25th at 9. Friday, June 26th at 9. And Tuesday, June 30th at 9.
Got it.
That works.
Okay. All right, so the court will send out scheduling orders in each file with those dates. And let's see, we'll need final pretrial conferences for those two. Sorry, let me do that. So for the March 31st trial, let's use March 25th as the final pretrial at 8:15.
And that's on Zoom, I'm assuming?
Yes.
Okay, thank you.
And the June trial, 15th won't work, so let's.
You could use June 10th for that final pretrial.
Okay, so let's go with June 10th then for the final pretrial for the June case.
All right.
Okay, so yeah, the court will send out scheduling orders with those dates in it. Is there anything else that we need to address today?
Mr. Bayonetto did want me to put the plea offer just on the record for record purposes if this was to be set for trial. So if I could just do that at this time.
Yes, go ahead.
Mr. Bayonetto is offering this defendant to plead as charged to count 1 in both files with a sentence agreement to 120 months in the Michigan Department of Corrections. The other counts and habitual offenders would be dismissed. And I don't know, I guess, when he or how long he leaves that offer open, but typically it's through the final pretrial.
Heard and noted.
Okay. All right, we're all set then. So Mr. Burgess, Mr. Sinclair, you can both go ahead and log out.
All right, thank you so much and have a good day.
Thank you, you too. You ever get through them about one? Ms. Underwood, whenever you want to come into the courtroom, I'm ready to do Mr. Broughton.
I'm sorry about you. I've tried calling upstairs, but it keeps saying that there's no one available. So I was on the phone issue with what Judge Olsey would like to have Michael Goble in a room, please. Thank you. Bye.
Can you have them bring Mr. Broughton in?
Not a bad approach.
Turn the volume on your device. Yeah.
This is the original of the signed plea agreement that Mr. Broughton signed.
He's going to need an advice of rights also.
I did.
This is file 25-22202-FH. People of the State of Michigan versus Cameron Joseph Broughton. We are here today for a pretrial conference in this case and proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure.
B.B. McClure, on behalf of the people.
Rhonda, I'll do it on behalf of Mr. Broughton, Your Honor.
All right, and sir, you are Cameron Joseph Broughton.
Yes, Your Honor.
Mr. I'm sorry, Ms. Underwood, how would Mr. Broughton like to proceed today?
Your Honor, we have reached a plea agreement with the prosecutor's office whereby Mr. Broughton will plead guilty to an amended count 2, Your Honor, attempted prisoner possessing weapon, a 2.5-year felony, with the habitual offender supplements being dismissed, Your Honor. The 5-year felony will, count 1 will be dismissed, and that is a complete recitation of the plea bargain, Your Honor.
Okay, Ms. McClure, is that a complete and accurate statement of the plea agreement?
It is.
And I do have a written copy of the plea agreement that's been signed by Mr. Broughton, and both attorneys also have an advice of rights form signed by Mr. Broughton that's in the file. Mr. Broughton, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
Mr. Broughton, you've heard the statement of your attorney, and you put your hand up. And the prosecuting attorney, is it your intention to plead guilty today to count 2 attempted prisoner possessing weapons?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 2.5 years in prison and or a $1,000 fine?
Yes, Your Honor.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That is correct.
Ms. Underwood?
It is correct.
Is that also your understanding, Mr. Broughton?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have at trial. I'm going to explain those to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Broughton, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
You also understand that any appeal from conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
You understand that you're giving them up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about December 7, 2024, in Madison Township, Lenawee County, Michigan, that you did commit the offense of attempted prisoner possessing weapons?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you're giving up any and all claims that that plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce
No, Your Honor.
Mr. Broughton to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Broughton, has your attorney promised you any particular sentence or estimated what your sentence would be?
She told me what I'm looking at, yes.
Okay. You understand, she's told you what the possibilities are, but ultimately it's my decision, the judge's decision on what your actual sentence would be.
Yes, Your Honor.
Okay. If your plea is accepted and you engage in misconduct, the court is not bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty to?
Yes, Your Honor.
Ms. Underwood, do you want to cover the factual basis?
Thank you, Your Honor. Yes. Mr. Broughton, I take your attention back to December 7th, 2024. At that time, were you an inmate at the Gus Harrison facility located in Madison Township, County of Lenawee, State of Michigan?
Yes, I was.
And you were lawfully imprisoned there, correct?
Yes. Correct.
And you were being searched, correct?
Correct.
And at the time you were searched, you possessed a weapon. Is that correct?
Yes.
And that was found by prison staff.
Correct.
And you had no legal reason to possess that weapon.
No. I did not.
I believe the factual basis has been established, Your Honor.
Is McClure, the people satisfied with the factual basis?
We are.
All right. Has the court complied with MCR 6.302 B, C, and D? Ms. McClure?
It has.
Ms. Underwood?
It has, Your Honor.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Broughton has had full knowledge of his rights. He's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for November 6th at 8:15 a.m. Mr. Broughton, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background.
Okay, Your Honor, sounds good.
Great. All right.
And Your Honor, are there fingerprints on this file?
Yes, there are. We're set there.
Okay. Do we need to do a Zoom writ or an in-person writ for sentencing?
Thank you. So, Mr. Broughton, you have a right to have the sentencing hearing conducted in person. So you to be here in this courtroom.
I would like in person, Your Honor.
Okay, we will do that in person then. And Ms. McClure asked to ask the prosecutor's office to do a Zoom.
Yes, we will.
Okay. All right. So with that, then we are all set for today. Thank you.
Thank you, Your Honor.
Have a safe trip back.
All right. Thank you.
That was November 6th, Your Honor. That was
November
November
6th.
6th. Thank you.
Are you going to need to speak to Brian Dennis?
I'm sorry.
Brian Dennis, are you going to need to speak to him?
I don't need to speak to him, Your Honor.
Okay, Mr. Goebel, your attorney stepped out. As soon as he is back in the courtroom, we'll get started on your case.
Okay, thank you.
And let's see, in the meantime, we will do file 23-21255-FH People versus Brian Matthew Dennis. We are here today for a hearing on a probation violation. We are proceeding today partially in person and partially by video conference. Ms. Underwood, do you want to place your appearance on the record?
Ron Underwood for Mr. Dennis this morning, Your Honor.
And where are we with Mr. Dennis?
Yes. OWI third charges have been filed against Mr. Dennis pursuant to this violation, Your Honor. And so Mr. Dennis has a probable cause that I will be representing him at 1 o'clock today, Your Honor. So we would ask for a adjournment of this matter for probably 2 weeks to get some idea of what is going to proceed on the OWI, Your Honor.
Okay, I can adjourn it to October 15th. That's 2 weeks from today, October 15th at 8:15 a.m.
I'm sorry,
October 15th
October 15th.
at 8:15.
Thank you, Your Honor.
Yeah. So, Mr. Dennis, your next date is October 15th at 8:15 a.m.
Okay, can I address something or ask you a question quick before we proceed? I have a curfew right now, and since then I've been put on 2-a-day breathalyzers, been attending AA, and got myself into a one-on-one counseling as well. And I was hoping to get off the curfews to enable me to go to my AA meetings, and my counseling I need to go to kind of conflicts a little bit with the time frame on my AA meetings.
Mr. Dennis, is that curfew on this bond or on your?
I'm not sure. It's at 8. I'm not sure exactly.
Yeah, Rhonda, the curfew is actually on the file upstairs here. He's got a
Okay.
curfew Monday through Sunday, 8 a.m. I'm sorry, 8 p.m. to 8 a.m.
I know it's 4:30
I've
a.m.
got
I believe.
4:30 a.m. I think we made an accommodation for his work schedule. So it's your counseling and your AA meetings are after 8 p.m.
No, well, sometimes I'll get out of AA, which is fine. Darren gave me permission to do it, but I was just hoping I could get the curfew dropped, but
Judge, maybe we can make the nightly curfew 9 p.m. rather than 8 p.m. That's so he could get his AA in. I know he does attend Serenity House at 7:30 on an occasion.
I'm willing to modify it to 9 p.m. And I mean, if you're really at AA, I'm not going to have a problem with that. But I think under the circumstances, I don't want you out at night if there's not something that has to be done. And so
I understand.
So we'll change it to 9 p.m. instead of 8 p.m.
Perfect. That works for me. Thank you very much.
Okay.
See you
all right.
this afternoon, Mr. Dennis.
All right. Thank you.
You're all set, Mr. Dennis. You can go ahead and log out.
All right. Thank you.
Ron, do we have Mr. Cherry in the?
He's not logged in, but I did get your information on him. I'll just.
I have copies of some bankruptcy documents.
Yeah, I got them by email.
Okay.
So this is file 22-20683-FH People versus Paul Edward Cherry. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. Courtroom is also open to the public. I have received, well, Ms. Underwood, let me ask you to place your appearance on the record.
Your Honor, Mr. Cherry has provided the court with notice of his Chapter 13 bankruptcy case and the proper documentation, I believe, in this matter.
I have received that by email, and so what I was going to do in response to that is just set this for a status conference and about what is going on with that.
Thank you, Your Honor.
And so you'll be looking into April. Let's go with April 1st at 8:15 a.m.
Thank you, Your Honor.
Okay. All right, Mr. Fry, are you ready to proceed with Mr. Goebel?
Yes, Your Honor.
Do we have any more, Your Honor?
What's that?
Do we have any?
Got a couple other
Okay, a couple more pickups.
probation violation. Yeah.
Okay,
Yeah.
thank you.
Okay, so this is file 24-21915-FH, 24-21916-FH, and 25-22117-FC. People of the State of Michigan versus Michael Ronald Goebel. We are here today for pretrial conferences in each of those cases, and we are proceeding today partially by video conference and partially in person. They have the attorneys place their appearances on the record, beginning with Ms. McClure.
Phoebe McClure, on behalf of the people.
Brian Fry on behalf of Mr. Goebel.
Okay. And Mr. Fry, where do things stand with Mr. Goebel's cases today?
Yes, Your Honor, Mr. Goebel had decided to invoke his statutory right for a polygraph. We're still waiting to try to get that scheduled, is my understanding. It hasn't happened yet, but we're working on that. So we'd ask for this to be adjourned so that can be accomplished.
And I can touch base with Detective Putnam and see where he is on getting that scheduled, but I know it was something he was working on.
Okay, so we do have trial dates set for December with final pretrial December 3rd, trial starting on the 9th. So we can adjourn this. But it'll be here before we know it. So let's go with October 22nd at 8:15, if that date works.
That works for me, Your Honor.
That works, and I will see it. Hopefully Detective Putnam can get that scheduled before then. A couple things I wanted to address with the court, though. I know we had set that trial date, but I searched our files and as well as the ROA, and I didn't see a scheduling order. I don't know if the court did one and maybe we just misplaced it, or if the court didn't do one. I was wondering if the court could. And in addition, back in May, I filed or sent to, I didn't file, but I sent to Mr. Fry a proposed stipulation to consolidate these cases for one trial. Because I haven't gotten that back yet, I'm assuming there is no stipulation to consolidate. So I'll need to file a motion for that, as well as, and I'll tack on the 404B at the same time so it all can be dealt with together because they're obviously the same issues. So I was wondering if the court could give us a motion hearing date as well.
How much time do you think you might need to argue that? Is that can be done in 15 minutes, or do you think you need more?
Mr. Fry, I guess I'll defer to you. I mean, between 15 and 30 minutes, do you think?
Yeah, I was thinking maybe more like 30 minutes for that, probably, Your Honor. Just to be safe.
Francis, could you find us a Monday morning? Do we have anything in the reasonably near future that we can do 30 minutes on a Monday morning?
November 3rd at 11:30.
I can do that.
Did the court say at 11:30?
Yes.
Okay, yes, I can make that work.
Okay, so you'll need to file your motion and do a notice of hearing with that motion so that the clerk's office gets it on the docket.
Okay, thank you.
And Mr. Fry, did you have a copy of the schedule? Well, I'll email you both copies to make sure you have.
Thank you. And Mr. Fry, when I send you my motion, I'm also going to send you a written plea offer, just so you have the actual plea form to go over with Mr. Goebel, just in case.
Okay, thank you.
I don't know if I understand what's going on.
I'll come in and talk to you, Mr. Goebel.
Okay.
Okay, I just emailed a copy of the schedule to both of you, so you should have that.
Thank you.
All right, so Mr. Goebel, you can let the officer that's with you know that you're done with court for today.
Thank you.
Okay, and Mr. Fry, you had Edward Edwards also, I think, is that right?
Yeah, I wasn't sure if you still had that on the docket or not. It was a final pretrial, but I know we got new final pretrial and trial dates from Francis, I think yesterday, but
Oh, it did, okay. He's got a bench warrant outstanding?
I don't think so, because he's the one that was in the hospital.
Oh, that's right.
Thought we dealt with that last
Yeah,
time.
I better make it for that.
But I can do it if you still have it on the docket, if he's here.
He's not here, but you've got new dates then?
Yeah, we got a new final pretrial and trial dates.
Okay.
Thank you.
We're all set with that.
I'm sorry. It's busy. Well, Judge Olsever needs Richard Chopra in the Zoom room, please. All right, thank you. Bye. So the schedule order, I go, was only in that last file. There is not one in the other two files. It only has that one file.
Yeah.
So is that go for all three files or just for the newest?
At the
file?
moment, it's just the one file.
Okay.
And he's gonna file a motion to consolidate two times. You also asked for.
Thank you. Bye.
Okay, Mr. Evans, can you hear me? Glazier, do you need to speak to Mr. Garot?
Yes, I do.
Okay, Mr. Evans, can you hear me?
Yes, sir, I can.
This is file 25-22262-FH, People of the State of Michigan versus Dustin Lee Evans. We are here today for a hearing on a summons for requesting summons for probation violation. We are proceeding today by video conference. Sir, you are Dustin Lee Evans.
That is correct, yes, sir.
Have you received a copy of the request and summons for probation violation?
Yes, sir.
That request and summons for probation violation alleges that you violated the conditions of your probation by failing to provide your analysis on August 24th, August 26th, August 30th, September 2nd, September 4th, September 6th, September 9th, September 11th, September 12th, and September 15th. Do you understand that that's the allegation against you?
Yes, sir.
You had previously pled guilty in this case to aggravated stalking. The maximum possible penalty for that offense is up to 5 years in prison. Do you understand that?
Yes, sir.
You are entitled to be represented by an attorney today and at any other hearings that we have regarding this matter. If you can't afford an attorney, you can tell me that and I'll appoint one for you from the public defender's office. Do you understand that?
I do, yes, sir.
Do you want to be represented by an attorney today?
Yes, sir, at least just to talk to one.
Okay. Do you have the ability to pay for your own attorney?
Not at the moment, sir, because I'm still paying for my divorce.
Okay. I don't have a public defender logged in right now. As soon as our public defender gets logged back in, I will I'm going to put you back in the waiting room for a few minutes. As soon as I have a public defender to speak to you, I'll bring you back in.
Okay, yes, sir.
Mr. Murphy, do you need to speak to Mr. Wilson?
Would this be Mr. Kareem, Your Honor? I'm sorry.
Oh, yeah, I'm sorry. Yes.
I do not, Your Honor. We're ready to proceed.
Mr. Henry.
Yeah, I'm sorry, Your Honor.
He's raising his hand, so I'll put you in a breakout session with him. Just a moment. Okay, this is file 22-20936-FH, 25-22330-FH, and 25-22331-FH, People versus Richard James Garreau. We are here today for a pretrial conference in those cases. There's also, the 22 cases of probation violation. The 25 cases are pretrial conferences, as well as show causes or contempt proceedings for alleged violations of bond conditions. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
Evie McClure, may I have the people?
John Glazier on behalf of Mr. Garreau.
All right, and
Your Honor, you said there's a violation of probation?
the 22 case is, I mean, that's not, hang on.
I don't think I had that one. At least I didn't know about it.
Okay, he was just arrested on that one last night or yesterday.
Okay, what's the violation of probation?
The violation was actually, I think we arrested and arraigned him 2 weeks ago on that. And he got bond. And so he's in here on right now on bond violations. And plus he has a arraignment date, or not arraignment, pretrial date today on violations. I don't believe you were present, John. It was somebody handled it for you.
I didn't know. I didn't know he was on probation. That's fine.
Oh yeah.
Okay. So
Mr. Moore is correct. We did see him and arraign him on that a week ago or 2 weeks ago. There was also just a warrant that I signed yesterday that I don't think I have back in front of me yet, but that one was a violation of bond conditions for testing positive methamphetamine, amphetamine, and ecstasy.
Your Honor, I think he has a prior contempt of court on that as well. He brought in he's got significant heart issues and he takes a lot of medication. He brought that list into Darren. He was supposed to bring it into me, but he didn't bring it into me. But
John, I did get that list. He has taken 11 medications. Out of those 11 medications, none of them is an amphetamine. So none of those 11 medications would make a drug test positive for meth or amphetamines. In addition, he's also tested positive for ecstasy. This is true for his last 4 drug screens.
Okay.
I got dirty. All 4 tests came back dirty for the same thing the last 4 times.
Yeah, is that what they're testing positive is for methamphetamine, Darren?
Methamphetamine and also ecstasy.
Okay. Your Honor, could we adjourn this? Maybe we can have Darren send me that list.
Yeah, I can adjourn it to next week is October 8th at 8:15.
And I don't have the violation of probation. I'd need those 2 sent to me.
Hey, John, I'll send that to you this morning. I'll send a copy of the warrant along with a list of the 11 medications that he's taken.
Okay. All right.
All right, so we'll adjourn this to October 8th at 8:15 a.m. Mr. Grow, you can let the officer with you. You're done with court for today.
And John, I emailed you the offer on the 2 pretrials on, it looks like back on September 11th. So I just want to make sure you have that to go over with Mr. Grow.
Yeah, well, October 8th at 8:15, did you say?
Correct.
I'll talk to you before that, Mr. Garrow. I'll Zoom with you.
So I'm stuck in here then?
I guess you are, yeah, until we can figure this out.
So I can't make see my cardiology appointment tonight then, at 4 o'clock.
I don't know. What appointment?
For my heart, I'm supposed to go see that, Samantha Sheridan at 4 o'clock in Jackson at Henry Ford.
I don't know, Your Honor. I guess I know he does have significant heart problems. That's why he takes all these medications. I don't know if the court would consider a PR bond so he can make his appointment with his heart doctor.
Oh, my issue with that is that I've done PR bonds. He's continued to test positive for methamphetamine and ecstasy. And the information I have in front of me right now is that the drugs, the prescription medications that he is taking would not make him test positive for methamphetamine and ecstasy. So what I will do is provide that he can be released from 1 p.m. until 6 p.m. to attend his doctor's appointment in Jackson. But he's got to come back and report to the jail at 6 p.m. after his doctor's appointment.
Okay, is that doctor's appointment today?
Yes, at 4 o'clock.
Okay, so somebody's gonna have to pick you up, but you're gonna have to come right back to the jail. Otherwise, it's an absconding, which is another felony.
Yeah, I know.
All
I
right,
just don't understand how I'm getting tested for this stuff,
Well,
they all come back the same thing.
I gotta look at this, but you're gonna get out from 1 to 6. Somebody needs to pick you up and take you to the doctor and bring you back. Okay?
Yep.
I'll talk to you with Zoom before the 8th.
Yeah.
Your Honor, do you have a Taisha West? Or I think I filed a waiver, but it's still showing up on my sheet.
I don't have a waiver on that I know about.
Is it set for today?
Yes.
Okay.
She is not logged in. You want to try to contact her?
I don't have my files, Your Honor. I do know I might have a waiver back at the office that hasn't gotten filed. What we did is we waived this up, and it's a larceny. It involves an ex-boyfriend, and the way that we left it was that they were going to talk to each other and see if they could figure out an agreement on how much she was going to pay to him. And I told her it'd be about probably 6 weeks. So I think I have a waiver sitting back at the office.
Okay, well, I'm not going to set it out 6 weeks unless I have it in. So
Yeah.
I can adjourn to next week. And if you get the waiver in the meantime, that's fine. But
Yeah, that would be perfect. I was going to say even tomorrow, but yeah, I can get it. If it
All
didn't
right,
get
so I'll-
filed, if it didn't get filed, I meant to get it filed. I know that. Because I told her she'd have, about 4 to 6 weeks to figure this out with him.
All right, so I'll adjourn it to October 8th, and then if we get a waiver, we'll just set a pretrial date.
Okay, thank you, Your Honor. I think the only other one I have is Gerald overall.
Okay. Yeah, can you call for Gerald? We'll call for him right now.
All right.
And let's see, Mr. Murphy, are you ready to proceed with Mr. Henry?
Yes, Your Honor.
Yeah.
If we have one count, Robert Morris. Great, thank you so much. Bye.
Okay, this is file 25-22326-FH People versus Kareem Jamal Muhammad Henry. We are here today for a pretrial conference in that case. We are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure, on behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Henry.
And Mr. Henry is here by Zoom from Lenawee County Jail. Mr. Murphy, where do we stand with Mr. Henry's case today?
Your Honor, Mr. Henry is asking if we could set another pretrial just a week or two out, whatever the court can fit in its schedule. Mr. Malaro is out on vacation until next week, and Mr. Henry wanted to see if Mr. Malaro can get a certain sentencing agreement with a plea. Right now, the plea offer, from my understanding, Ms. McClure relayed to me that the plea offer would be to plead to count 1, which is a 4-year felony larceny with payment of restitution before sentencing. I believe that would I'm sorry, what would the payment of restitution before sentencing would allow for, let's see here, get credit for time served if that was made. So as it is right now, again, that would be to a felony. Mr. Henry was wanting to plead to a misdemeanor in the matter. So again, just 1 week or 2 weeks. I believe 1 week may be sufficient. Again, Mr. Moore is supposed to be back, I believe, by Monday, so maybe you can get something figured out by then. But maybe 2 weeks might ultimately be the reality of the situation.
Okay. So I can, let's see. I can set that for next week is October 8th at 8:15.
Can we do that, please, Your Honor? Again, I'm hoping something can get done. If not, I guess it'll be readdressed at that point.
So next week, October 8th at 8:15 a.m.
Yes, Your Honor. My office do a stipulation order for that date and time.
Okay. Anything else we need to address with the case today then?
Nothing from the defense, Your Honor. Thank you.
Nothing on behalf of the people.
All right, Mr. Henry, you can let the officer with you know that you're done with court for today then.
Okay, thank you, John.
Thank you.
Thank you. And the gentleman that just got in the Zoom booth, are you Mr. Morris? Sir, are you Robert Morris?
No, I'm not.
What's your name, sir?
Oh, Gerald overall.
Yeah, I'm sorry. Okay. Mr. Glazer, do you need to speak to Mr. Overall?
Yes, I do, Your Honor.
Okay, 1 second. And Mr. Murphy, do you need to speak to Mr. Morris?
I would, Your Honor, please.
to those Zoom booths, you should have something on your screen asking you to join a breakout session. Click join or accept or whatever it's asking you to do.
Yes, sir.
Okay, this is file 25-22410-FH, People versus Gerald Marshall Overall Jr. We are here today for an arraignment in this case. We are proceeding today by video conference. First, can I have the attorney place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, we have the people.
John Glazer on behalf of Mr. Overall.
Mr. Glazer, does Mr. Overall wish to have the information read today?
We'd waive the reading of that, Your Honor. I don't have my file in front of me. Unfortunately, I left my files at the office. Is count one, is that a 2-year felony?
It is.
Correct.
Okay. Yeah, he's going to plead guilty to that, Your Honor, with the understanding that the sexually delinquent person would be dismissed at the time of sentencing.
And that does appear to be the plea. I don't know the facts of the case because this is Mr. Bandetto's. Uh, but I just wanted to point out as well that SORA could apply depending on the facts, but it also may not. So I don't know if that's something that was gone over with Mr. Overall, but I just want to make sure that's on the record.
Oh, yes, yes. Oh, yes, yes, it is. Yeah. He went over it with me. Yeah. I agree to it.
Okay. Let's see, we need to have an advice of rights form signed. Could you call the jail, see if they can take an advice of rights?
I can prepare a plea form as well fairly quickly if that helps.
I don't think I need it right now, but whatever you want to do in that regard is fine. I do need the advice of rights form.
John, do you want a plea form, a written plea form?
You can send it, you can email it to my office. I'm not at my office, so yeah. I'll get it down to him at the jail.
Mr. Glacier,
Yes.
somebody came to visit me in the jail last Thursday. I can
Okay.
tell you. Did you find out about that?
No, somebody from my office?
No, he says he was something about the bond, somebody bond.
Bondsman?
Yeah, last Thursday. I know you're aware.
I don't know anything about that. Maybe one of your relatives sent it.
No, this is actually a white guy. He came, but he came.
Yeah, I don't know who it was.
He had came here. I thought you might have been aware of it.
All right. No, I wasn't aware of it.
Am I supposed to sign this or?
The vice of rights, yeah, you got to read it. Those are the rights you're giving up by pleading guilty.
Where do I sign it at?
Should be toward the bottom, the right-hand side.
Okay, I sign.
Okay. Okay, so will you raise your right hand, Mr. Overall? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Gerald Marshall Overall Jr., is that correct?
Yes.
You can put your hand down if you like. You've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to aggravated indecent exposure?
Okay.
Mr. Overall, is it your intention to plead guilty today?
Oh, yeah. I'm sorry. Yes.
Okay. Do you understand that the maximum possible penalty for that offense is up to 2 years in jail and or a $2,000 fine?
Yes.
Do you understand that if the victim in this case was a minor, that this is a tier 1 offense under the Sex Offender Registration Act that would require your registration as a tier 1 offender?
Yes.
Do you understand that if you have a prior conviction for any tier 1 SORA offense, that this would be a tier 2 SORA offense that would also require your registration under SORA?
Yes.
And you also understand that if you have any prior convictions for a tier 2 SORA offense, that this would be a tier 3 SORA offense that would require your registration as a tier 3 offender.
Yes.
Neither the prosecutor, defendant, nor anyone acting on the defendant's behalf has discussed possible sentence with the court. Is that correct, Ms. McClure?
That's correct.
That's correct, Your Honor.
Is that also your understanding, Mr. Overall?
Yes. Mr. Overall, are you satisfied with Mr. Glazier and the advice that he's given you?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you were guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Overall, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any conviction pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving them up?
Yes.
How do you wish to plead to the charge that on or about September 9, 2025, in the city of Adrian, county of Lenawee, state of Michigan, that you did commit the offense of aggravated indecent exposure?
Guilty. Yeah, guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Overall to plead guilty today?
None, Your Honor.
Mr. Overall, has your attorney promised you any particular sentence or estimated what your sentence would be?
I don't think he. No. I think he's discussed something about the sentence.
I've only advised him of the maximum sentence, Your Honor.
Okay. You understand, Mr. Overall, that ultimately whatever your sentence actually is going to be up to me as the judge.
Yes.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes.
Is it your own choice to plead guilty today?
Yes.
Mr. Glazer, do you want to establish the factual basis?
Yes, Your Honor. Mr. Overall, first of all, the judge talked about SORA. You understand that that's sexual offender registration. That's what that means. Do you understand that?
Yeah. Yes. Yes.
Are you on SORA now? Do you have to register? Do you have to report every year or keep that up to date?
Have I up to prior to now?
No. Are you required to register as a sex offender? Is that something you're doing now?
No.
Okay, but you understand that that's something you're going to have to do, and at sentencing, judge will tell you how long you have to do it for. Okay.
Okay.
All right. And on or about September 9th of 2025, you were here in Lenawee County, Michigan. Is that correct?
Yeah.
And at that time, you had exposed yourself. Is that correct?
Yeah. I'm guilty. Yeah. Yeah. Yes.
No, not that you're guilty, but you got to admit you did in fact
yes,
expose your penis. Is that correct?
Yes.
And you were either masturbating or touching yourself at the time you were doing that. Is that correct?
Yes.
Okay. I don't have any other questions, Your Honor.
I have one follow-up, and was that in fact in front of, or did a minor see that? Would be an 11-year-old with the initials SG?
Yeah, I admit that, yes.
Okay. People are satisfied, Your Honor.
Okay. Do you understand, as Mr. Glazer said to you, that since the victim here was a minor, Mr. Overall, that is a tier 1 offense, which will require you to register under SORA for a minimum of 15 years.
Okay. Yes. Okay.
All right. And you still want to proceed and enter your plea?
Yes.
Okay. Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Glazer?
Yes, Your Honor.
I will accept a plea then. It's been given understandably, voluntarily, and accurately. Mr. Overall has had full knowledge of his rights, and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case. prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for November 7th at 8:15 a.m. Mr. Overall, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Yep, I will.
Okay, so you are all set for today. You can let the officer with you know that you're done with court for today.
Okay. All right.
Judge, what was that sentence date?
November 7th.
Okay, thank you.
Thank you, Your Honor. I think that's all I have with you this morning.
Okay, thank you, Mr. Glazier.
All right, we'll see you later.
Hey Phoebe, could I get the police sheet on overall, please?
Yes.
Thank you.
Okay, let's see. So this is file 25-22334-FH, People of the State of Michigan versus Robert Scott Morris Sr. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Morris.
Okay, and Mr. Murphy, where do we stand with Mr. Morris's case today? I'm sorry, he does have a pretrial. There, in addition to the pretrial, there is a pending contempt. So, Mr. Murphy, where do we stand with Mr. Morris's case?
Your Honor, in regards to the contempt, Mr. Morris wanted to accept responsibility and plead guilty to those. In regards to the underlying charge, I had in my notes, I thought that there was an offer for him to plead to use with no upfront jail. I wasn't sure if that was still valid. So I think in regards to the underlying, if the prosecution wouldn't object, I'd be inclined to just ask to adjourn that and get confirmation. He does have new pending misdemeanors downstairs. I don't think those are going to impact things ultimately, but I just wanted to get more clarification about if that offer is still available or not. So again, today, if we could just adjourn that, but address the contempts and have him plead guilty to those, and then address bond in the matter.
One second.
Hmm.
Okay, Mr. Morris, would you raise your right hand, please?
Yes, sir.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Robert Scott Morris Sr.?
Yes, sir.
Mr. Morris, do you understand that the maximum possible penalty for contempt of court is up to 93 days in jail or up to $7,500 in fines?
Yes, sir.
Are you satisfied with Mr. Murphy and the advice that he's given?
Yes, sir.
Do you understand that you have a right to contest these contempt of court charges and to have a trial on them?
Yes, sir.
Do you understand that throughout that trial, you would be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes, sir.
You have the right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. And you also have the right to have me order any witnesses you might have for your defense to appear at your trial. Do you understand all of that?
Yes, sir.
You are not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, sir.
On the other hand, you have the right to testify if you wanted to testify. Do you understand that as well?
Yes, sir.
How do you plead to the charge that you commit a bond violation by failing to do twice weekly drug testing?
I plead guilty, sir.
And how do you plead to the charge that you committed contempt of court by failing to appear at your pretrial on September 3rd, 2025?
I plead guilty, sir.
Do you understand that by pleading guilty, you're giving up your right to a trial, your right to have your lawyer's assistance at that trial, as I've already explained?
Yes, sir.
Has anything been promised in order to get you to plead guilty?
No, sir.
Has anybody threatened you in any way in order to get you to plead guilty?
No, sir.
If I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty?
Yes, sir.
So you had bond conditions that required you to do some drug testing in this case. Is that correct?
Yes, sir.
And you're supposed to do twice weekly drug tests. Is that right?
Yes, sir.
And as of as of July 31st, when the warrant was signed, you had not done any drug testing at that point. Is that correct?
Yes, sir.
And you also had a pretrial conference set for September 3, 2025. Is that right?
Yes, sir.
And you did not appear here in court or log into the Zoom session for that hearing. Is that right?
No, sir, I did not.
All right, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Morris has had full knowledge of his rights and he has had competent counsel. Mr. Murphy, before the court passes sentence, is there anything you'd like to say on behalf of Mr. Morris?
Yes, Your Honor. In regards to the failure to test, Mr. Morris had brought this up when we were down in district court, and we raised the issue in front of the district court about his income or his lack of income and the financial burden. It's hard to really appreciate, but it is a lot of money, even what appears to be a small amount. And I've expressed that to him, the district court, I believe, and it has been expressed to Mr. Morris that he can go to the probation, district court probation, and I think the cost is $5 per test. Mr. Morris understands. I explained to him that at this time, if the court orders him to test, he has to test. They're doing what they can to reduce the cost. He has to come up with the money somehow, borrow the money or return bottles. He understands that he has to make that, he has to come up with something to make that testing. He was asking the court to consider maybe reducing the testing regimen, maybe to once per week during the pendency of this case. Again, I believe that the underlying charge is going to be worked out here momentarily, or fairly soon, I mean. I just wasn't sure, given the misdemeanors downstairs, the impact of anything on that with his sentence, what it might be. But again, I don't believe that Mr. Morris is intending to, ignore the orders of the court or ignore the authority of the court. He does apologize for missing a September 3rd date. Again, he does have, quite a bit of financial hardship trying to make the obligations for the bond violations over the bond conditions. So in regards to a sentence, Your Honor, I'd ask the court to consider credit for time that he served. I believe he's been in custody now since September 7th or 8th. I do believe that he has another date down in district court on October 7th for his cases on that, where he does have bond holding him right now. So I'd ask the court to consider giving him a sentence of credit for time served. I don't believe any further incarceration is necessary on the bond violations. I don't believe a fine is appropriate given his financial hardships. And I don't think probation is done on violations of bond. So I believe credit for time served would be appropriate, and then allowing him to be released, giving him again a PR bond with maybe considering reduction of the bond conditions for testing. I do believe he's probably going to be held until September or until October 7th. I don't think he can post the bond downstairs right now. But I just want to make the court aware that it would be intention to address the bond on the 7th of October down in district and see if he can be released at that point. So that's going to consider credit for time served and allowing him a PR bond moving forward on the underlying charge. Thank you.
Mr. Morris, is there anything you'd like to say on your own behalf before the court passes sentence?
No, sir. I just, when I get out, I'm just trying to find me a job. They're supposed to down in Port and Bottom. They're supposed to help me try to get my driver's license back.
Right, it's going to be set to report that Mr. Morris served 30 days in the Lenawee County Jail with credit for 23 days served. I will reinstate the PR bond after that. Mr. Morris must report to Mr. Coast as often as he requires, must not use alcohol, marijuana, or any illegal controlled substance, must participate in a substance abuse or testing or monitoring program as directed by Mr. Coast. Again, that we've got arrangements for you to do that at $5 a test.
Yes, sir.
And you must continue to seek employment or find a job of some kind.
Yes, sir.
All right, and so we need another date for a pretrial. How far out do you want to look, Mr. Murphy?
Just a few weeks, Your Honor, whatever fits the court schedule best. 2-3 weeks, whatever.
Let's go with October 15th then at 8:15.
Thank you, Your Honor. My office do the stipulation order for that date and time, October 15th at 8:15.
All right.
Mr. Morris, when you do get out of jail, come up to the 3rd floor. When you come out, elevators go across the hall. Tell them that you're there to see Darren. And I'll meet you on the hallway. Yep.
Sure. Thank you.
Thank you.
He didn't plead to the new the underlying charge, correct, Your Honor, just to the contempt?
That is correct.
Thank you.
Okay, Mr. Evans, are you there? Mr. Morris, you can let them know that you're done with court.
Okay, thank you, sir.
Yes, sir, I'm here.
Okay, Mr. Evans is going to put you in a breakout session with Ms. Underwood from the Public Defender's Office. I have files for Brian Collar, but he's not on my docket.
Thank Doc, he is off.
Your Honor, I'm sorry. Was there anything else that you had me down for this morning? I wasn't sure if there's anything else that Mr. Malauer had that maybe I didn't catch.
No, I am all set.
All right. Thank you, Your Honor. Have a good morning.
This is probation. Okay, we are back on record in file 25-22262-FH People versus Dustin Lee Evans. We are here today for a hearing on a requested summons for probation violation. Mr. Evans had requested an attorney, and Ms. Underwood, you've now had a chance to speak to him. Do you know how Mr. Evans would like to proceed today?
Yes, Your Honor. I believe, I'm sure it's probably a typo, but the request and warrant gives dates that are after he was required to report, Your Honor, that are before he was required to report, or after, or before he was required to report. I'm sure it's a typo or something, and I believe we would like to plead not guilty at this point, Your Honor. I believe Mr. Evans probably would like to explain to the probation department why he did not report at what I assume were dates in September.
Your Honor,
Yeah,
can I speak?
go ahead.
At Veterans Court on September 24th, I think that was our last Veterans Court. You had
Yes.
indicated to Mr. Evans that if he, between now and then, if he did everything that he was supposed to do, that you would dismiss this. And he has done everything he's supposed to be doing with me between then and now.
Okay.
Thank you.
All right, so based on that, we did have a discussion about this during our last Veterans Court session, and Ms. Teskey is correct. It did indicate that if Mr. Evans, you started to comply and do all that you needed to do, that we would dismiss this. We did issue a sanction through the Veterans Court process, and I believe Mr. Evans has served that, and so based on all of that, I will dismiss this summons for probation violation.
Thank you, Your Honor.
Thank you, sir.
Okay. All right, so we're all set then, and Ms. Teskey, does he know when his next report or next activity
Yes, Your
is?
Honor.
Yes.
Yes.
Okay. All right, so you're all set then, Mr. Evans. Thank you for your time and patience this morning. You can go ahead and log out.
Thank you. I appreciate it. Thank you, Sarah.
Good luck,
You're
Mr.
welcome.
Evans.
Thank you. Bye.
So that's it.
Your Honor, I believe I still have Mr. Garcia on my list.
I do not have a Garcia on my docket for today.
Ricardo Garcia.